Which court do you go to, where is it, and when do you do that? How you figure out which court to go to, where it is, and when to go is based on the concept of jurisdiction. There are three types of jurisdiction to pay attention to: geographical location, which is also known as venue, subject matter jurisdiction, and the financial value of the case. This information is contained in the Code of Civil Procedure, which you can look at the public library or find on the internet. The general rule is that you start your court case in the geographical location, venue, where the dispute is, and if there is no location, you file in the county where the defendant or the respondent lives. Check out Code of Civil Procedure Section 392 and the following to find out where your case should be filed. As you prepare your judicial counsel forms to start your lawsuit, reading them will help you figure it out. A call to your local court clerk or the small claims advisor might also get you information you might need. You might also be able to find it on the internet. If you want the court to order the other person to do something or to stop doing something, this is called an injunction or a restraining order, you will go to the court designated in your county for this purpose. Sometimes this will also involve payment of money. These cases fall under subject matter jurisdiction, which are handled where they are assigned in your county. Examples of this are guardianship, probate, domestic violence, civil harassment, divorce, and related family law matters. You should be able to find out this information by calling your county clerk's office. In Contra Costa County, for example, our family law courts are all located at 751 Pine Street, Martinez, but domestic violence actions are first heard in the court closest to the petitioner's home. The financial value of a case can also determine which court you're to file your case in. If you are seeking a payment of $5,000 or less, and this is not a lawsuit between you and your spouse or domestic partner, you would go to small claims court. If you are seeking a payment of more than $5,000 but less than $25,000, you will go to limited jurisdiction court. If you are seeking payment of more than $25,000, you will go to the unlimited jurisdiction court. For example, if the case involves real property, like a house or an apartment or a condominium, the case should be filed in the county where the property is, and then in the court in that county, determined by the cash value of the case. For example, a landlord-tenant matter, also known as an eviction, in Pittsburg, California, would be heard in the limited jurisdiction court in the Delta Courthouse in Pittsburgh. But if that same case were over who is the owner of the property, it's probably worth more than $25,000, and it would be heard in the unlimited jurisdiction court in Martinez. Another important thing to pay attention to is timing. This is also called the statute of limitations. When should you file your lawsuit? Remember, if you snooze, you lose. Some cases go real fast, such as a landlord-tenant case. Others can take a long time. For example, a lawsuit over a written contract can be filed up to 4 years after the breach of that contract. You can look up the details regarding most cases in Code of Civil Procedure sections 335 to 366.3. Some cases get started whenever the time is right for you, such as a dissolution. That means a divorce. At the very beginning, you might want to consult with an attorney to help you learn what, where, and when. You can call your local bar association's attorney reference panel to get a low-cost consult, or check out any self-help workshops or legal aid agencies to get you started. If you are good on the computer, you might be able to research it for yourself.